Welcome to Canadian Innovators, the show that celebrates innovation, entrepreneurs, and the Canadian spirit. My name is Catherine Swift, and every week we introduce a new entrepreneur or expert on a relevant business topic to tell their stories and address the challenges of keeping jobs in Canada and discuss potential solutions for job growth and prosperity. Today I'll be speaking with Bruce Pardy, Professor of Law at Queen's University, Executive Director of Rights Probe, a law and liberty think tank, and Senior Fellow with the Fraser Institute. Bruce has been a longtime defender of civil liberties in Canada, as well as free markets and free speech. He's taught at law schools in Canada, the US, and New Zealand, started his career as a civil litigator in Toronto, has served on the Ontario Environmental Review Tribunal, and has been widely published in the media. Welcome to the show, Bruce.
Thank you, Catherine. Great to be with you.
Well, there's been quite a lot of very important court decisions that have happened in the last couple of years. And one major recent one is the recent federal court decision to declare the Liberal government's use of the Emergencies Act in the trucker convoy protest to be unreasonable and stated that it infringed on protesters' charter rights. The case was argued by the Canadian Civil Liberties Association and the Canadian Constitutional Foundation, among others. I know you said from the very first moment that the Liberal government's use of the Emergencies Act against the trucker convoy was clear overreach. You got to feel pretty good about this court decision.
Absolutely. Yeah, it's a great decision. It was not to be taken for granted because, you go to court and who knows what's going to happen, but it's a sensible decision. It's what I might call an ordinary decision in the sense that the judge has done his job. And he took the words of the statute, which is what you're supposed to do. The statute contains thresholds for invoking the act. And he looked at what the words of those definitions meant, as is appropriate, and decided whether or not the facts fit the thresholds and decided that they didn't. So he did exactly what a court is supposed to do. And so I think the outcome was pretty obvious. I think this has been clear overreach from the very beginning, like not even in the right ballpark for justifying an invocation of the Emergencies Act. But you can't take that for granted. And so, kudos to this judge for doing a good straight up job.
And he was a Liberal appointee, too. I think it's worth saying. So that's kind of interesting. I know a lot of people didn't think that this would be the outcome and that a judge wouldn't decide against the federal government. What do you think the key factors were that led the judge to make this conclusion?
Well, yeah. So you have different outcomes sort of between this case and the commission that we had earlier. But of course, the commission had a different mandate. And, one should not have expected the commission to come out with a different answer than it did. But in the court decision, so let's put some context here. So this is the first time that the Emergencies Act has been used. It was passed in 1988, and the reason it was passed is that the previous act, the War Measures Act, was used in 1970 by Pierre Trudeau when the FLQ was committing robberies and bombings and murders, actual violence. And at the time and later, that the use of the War Measures Act under those circumstances came to be viewed as overreach, as in, even though you have robberies and bombings and murders, it's still not enough to justify the use of this act. And so they made a new act, which was supposed to be even more difficult to trigger. But the circumstances under which this was triggered didn't compare to the FLQ situation. There was no violence, there were no robberies, no bombings, no murders, no violence of any kind. And yet the government saw fit to invoke the act, which was not the way it was supposed to be. And this judge interpreted the requirements of the act correctly. And as I say, that's is a nice job.
Maybe it has something to do with Trudeau, since they seem to be the only ones that bring this particular law to bear. Why do you think the commission decided in the reverse way to the courts?
Well, the commission doesn't have the same kind of mandate, right? It's not strictly a legal mandate. The job of the commission was not strictly to decide the same question that the court was there to decide. The court was there to decide whether or not the invocation of the act was lawful.
Right.
But
We're going to have to take a quick break now. Sorry, Bruce.
sure.
But
Yeah.
please stay tuned to Canadian Innovators.